Good morning, everyone. Welcome, welcome. I'm just going to put in my phone numbers in here. Good morning. Good morning, Instagram. Good morning, Facebook. Good morning, YouTube. Good morning, Shamika. Good morning, That Photography. If this is your first time, welcome to the side of the internet. My name is Aisha Chidole. I'm an immigration attorney and I practice in Atlanta, Georgia. But I present clients all over the 50 United States. We handle all family based immigration cases, humanitarian based cases like VAWA, U visas, T visas. So T's are for victims of labor trafficking, U visas are for victims of a serious crime, and VAWA for those who have been abused or experienced extreme cruelty with certain U.S. citizen or green card holder family members. We also handle removal defense at the firm. If you'd like to schedule a consultation, definitely contact us. My number is 678-325-1037 or 678-233-2170. It's also pinned in my in the comments on Instagram. So I'm sure you can see the pin for those of you that want the number. And if you're in Facebook or YouTube, the number is going to the ticker. As always, share this live with anyone you know who is dealing with immigration issues or might learn something about immigration issues. If you want more information after the live, you can always comment yes, and someone will reach out to you after the live. But today I wanted to start with some good news about my own clients specifically. Someone's asking a question about the 75 country pause. I'll get to that, but I wanted to talk about last week, Friday. I had mentioned to you guys yesterday that I was waiting on a decision, which I guess, I went on live before I checked, but, our client filed for his spouse and two stepchildren, and their interview was on Friday. Again, the typical, to give you like just some stats, this was a client from, the Caribbean, from Jamaica. They overstayed. They had worked without authorization. And then, of course, the two children who were minors under 21, under 18 in this case. And all three of them were invited to the interview. And so their case ended up getting approved. So their interview was, on the 11th, and the I-130 was approved on the 12th, which I think was Friday. And then on Saturday, they approved all their green cards, which would be the 485. So all three of them got their green cards approved. And I posted it in my profile as well. And then, two of the new green cards that we got. And one case for one of our clients from Nigeria where they filed their case and their case was denied. So we filed an appeal. They filed their case on their own and was denied. We filed an appeal and that was reopened yesterday. So I posted that on my timeline. Again, it's these days, any win you get, just because there's been such a delay, it's always very exciting. And especially to give people hope that, they are still making decisions. And I know that a lot of times you hear breaking news or this announcement or that announcement. But as we've told you guys, they are still processing adjustment of status in the normal way they will process them. This particular client, one of the things we prepare them for was to be able to answer the question of why they chose to consular process. Why they chose to do the adjustment of status here in the U.S. as opposed to, going out of the country. So I would say that was one question that they asked them. But, the officer was actually kind of like, I see no problem approving you, like during the interview. So we knew it was coming. Anyway. Okay. So someone is asking on, so that's my good news, but someone is asking if someone is outside the United States and they put a ban on the case 212F after the first interview, what can I do in this case? Well, right now, there's nothing you can do, because what that means is basically that they cannot approve the case because of the president's proclamation, the presidential proclamation. So assuming you're probably from a banned country. So I don't know if you're from a partially banned country or a full banned country. So the only thing you can do now is wait until the ban is lifted, and then you can usually reach out directly to the consulate. That should have been included in your letter, or they should have either given you that information. You can check that. Okay. Good morning, Suzanne on Facebook and MJ on YouTube. All right. Someone says, is there a forecast for immigrant visas to return to the 75 countries? We don't have a forecast. Well, I don't have a forecast. So I can't tell you the date or time or when. But, we are, of course, watching and following, because it impacts, some of our clients as well. So, as we find out more, I will share more. What I had mentioned yesterday. I talked about this yesterday about our client who had the interview in one of the partially banned countries, and basically I literally read out what it said, which is where they were directed to directly contact the consulate with their email provided once the ban is lifted, and what subject line they should put. So based on that, I anticipate that they will prioritize that, because they've already finished the interview, like once the ban is lifted. Because typically, you go through after you go through your NVC and your case gets documentary qualified, you usually move to the consulate. And then, the consulate, they first of all do a document review interview, and then they do an actual interview after that. So if you've already done that whole process, really the only thing, and if the only thing that is stopping them from making a decision is the ban, you will get that basically saying contact them once the ban is lifted. So depending on when the ban is lifted, some people might need to do a new police clearance, just because this police clearance do have an expiration date. So that might be something you need to do. But if everything else is done, I don't anticipate a new interview or whatnot. But again, I will keep you guys up to date as we find out more. Sweet Smile says, top of the morning to you. I haven't heard that in a long time, but same to you. Good morning. Jamaica says, Jamaica in the house. Good morning. Blue Trillions, good morning, Miss Aisha. You've obviously proven yourself to be the best at what you do. Thank you so much. I appreciate that. Is the pause for Jamaica I-130 case lifted? Hear me and hear me well. There was never, ever a pause on Jamaica I-130s. There was never a pause on that. Never a pause on that. So this is example of why I say, like, there's so much misinformation or overlap with a lot of the bans and pauses that many people are confusing certain things. But Jamaica never had a pause on the I-130s. Those were always being processed. And even for countries who have partial bans or bans outside of the United States, in-state, they have been processing those I-130 cases since March. And again, that's the reason why I post them, and I post their country so that you can find your country there, so you know that those have been lifted. What they had here was a pause on EADs, 485s, and naturalization for the people that had a 39 country ban outside of the United States, but that has also been lifted. Now, this current administration has filed a notice to appeal that judge's decision from last week. So a notice to appeal basically means that we're letting the court know that we plan to appeal. They have not actually given a brief or what it is that they're appealing, essentially. They're just saying they plan to appeal. So I guess they're going to be looking for what it is that they're going to be claiming that they're appealing. But basically, it's like you preserving your right, because, you basically have 60 days where you say, okay, we're preserving our right to appeal. We haven't provided the appeal, but obviously that's going to take months, for between them and then the judge to adjudicate or whatever the case may be, just like it took months to get to this place here in June based on the January case. And that's why, when we say when you're eligible for something, you should file because this thing's open, close, so that when it's open, they can adjudicate your case. One of the things that I would recommend right now, and if you're from one of those 39 countries and you have passed the normal processing time, right now is actually to do congressional assistance, and because you want to take advantage of the fact that the adjudicative pause has stopped right now to try and get a decision on your case before anything on appeal, because obviously we never know what the next court or the next judge is going to decide. Honestly, I rarely make guesses and speculations just because a lot has been very interesting. But when you look at the complaint and what is alleging and what the administration has done with this particular pause, it will be really shocking to find a judge, on an appeal level that will not agree that this pause should be lifted as well, based on the basis, because the thing is, you wanted to do a pause for 90 days, and then instead of 90 days, you just kind of left it there without really giving a direction, which is what they said. So I think that is going to be a real challenge for them to overcome, which is great. Again, I can't predict anything, and I rarely do guesswork, but I think this is one of the things that I'm going to be thinking. So someone says, I'm from one of the defunct partial ban countries. I had my interview a month ago. I was given a verbal approval for family AOS here in the US. What's the next line of action? In your case, 1 month is just not a long time. Even if you were not from a pause country, you need at least 90 days before you take action. They're still within the normal processing time post-interview. So they are probably just doing like security clearance. After 90 days from the interview, that might be a good time to, do congressional assistance if you've not heard anything. Just because at this point, they've removed my favorite agency, which used to be the Ombudsman, because I felt like the Ombudsman was the most effective in getting USCIS to take action or move. Now you have to deal with like your congressman, and oftentimes I have to assess who the congressman is, or congresswoman, or senate or senator, depending on your zip code or your state, because not everybody is a zealous advocate for immigrants, as you know. Like, some people are on one side of the fence. So we'll look to see if this is going to be something that is realistic. And, if you really do have that slam dunk case, of course, the next course of action is a mandamus, which is where you file a lawsuit. With mandamuses and lawsuit, I always say, if you want to do that, you really, really, really want to make sure that you have a slam dunk case. And when I mean a slam dunk case, there is nothing in your history potentially that USCIS is going to bring up as an issue. Okay. Mac Empress is saying, anything on VAWA? What particular question do you have on VAWA? Do you have any specific questions about it? Is there any situation where you would advise someone to reapply for the same benefit when a decision has not yet been made, but it's been an unusually long wait? The only situation that I would do that, which I actually recommended to somebody yesterday who came to us to do a FOIA, was that they filed a case. The case was denied. It was put on appeal. They filed an appeal, but that appeal has been pending since 8 years. In that case, technically, they have made a decision. They have denied the case. The appeal is just waiting. The FOIA did not indicate that the case was remanded back. Sorry, let me correct myself. The appeal was actually remanded back to USCIS, but there's no evidence that USCIS reopened that case. So my suspicion is that that case is either lost or it's just sitting there and nobody has that file anymore. And in that case, it makes sense to refile. I actually had a case in Trump 1.0, so this was in 2019 or so, where they came to me because they had filed for a marriage-based case for like 5 years. And, basically they didn't understand why. They hadn't heard anything. They had gone to an interview, all of that, and then I got the FOIA to look at the FOIA just to see if I found anything, and I looked at their FOIA. For those of you who don't know what FOIA is FOIA. It's just Freedom of Information Act. It basically means where you ask the government to send you the client's entire alien file so you can review it and see if there's any issues or red flags or anything that you need to know that might be causing this. And I looked at it and I was like, there's nothing here. This couple are still married. They have a child together. So I scheduled for an info pass. I truly do miss the days where we attorneys could do an info pass and actually go into the field office ourselves. We can't really do that anymore, unfortunately. But I went in and, I asked to speak with a supervisor. And, the supervisor, she waited she was out there for like 30 or 40 minutes. And this was in Orlando. And she eventually came out and she was like, they found the file, but that she just wants to start with an apology because the file was basically just sitting in a corner, and just forgotten that there was actually an RFE. I guess whoever was working on the file was going to send an RFE asking for them to submit a new medical because their medical had expired, but maybe the person left immigration, like no longer worked there, and it just basically was just slipped through the crack. And had we not come there, that person would just be sitting there wondering, for 5 years. And so what ended up happening was, we just ended up. So I was like, okay, well, can you? Let me correct myself. So what happened was they actually denied the case. They had in their system that they denied the case because they didn't get back the medical, but the clients never received the denial letter, and the FOIA didn't have the denial letter. So what they ended up doing was they ended up reopening the case, issuing the RFE so that they could do the medical, and then approving it. And I remember the officer apologizing, saying human error and, all of that stuff. So some in that scenario, that's what it would be. So I don't know what you're considering an unusually long wait. I don't know if you've done a FOIA. I don't know if you've had an interview. So there are just so many variables to determine whether or not you should refile. So it's always good to consult with an attorney, just to make sure that you've reviewed all your files to see what might be causing that. Okay. Someone says, I have a pending asylum that was filed in 2017, a U visa filed in 2021, and VAWA in 2024. Dang, you have a whole lot going on. Based on your experience, which one is likely to be decided first? And does having all three cases pending under the same A number affect processing? For the latter part of the question, having all three cases pending doesn't affect the processing. You just so happen to have cases that take an extremely long time. I would say that you're probably going to hear from the asylum based on the fact that it's been pending now for 9 years, probably much more sooner than you will for U visas. U visas take a really, really long time because they do have a cap per year that they have to meet. So U visas, you're looking at 7 to 10 years. VAWA case is about 4 years, and you filed in 2024. So do with that what you will, but my guess doesn't mean that that's what's going to happen, but that's what I presume. The ban on the 39 countries affect the citizens of those countries who have a case in the United States. I'm not sure if I understand your question correctly, but if what I think it is, if what you're saying is that if you were in part of the 39 countries outside of the US, what about if you were in the US? There was an adjudicative pause on those cases in deciding the 485, which is your green card, your EAD, and your citizenship. That pause was lifted. The hold has been lifted. And USCIS on June 12th has issued a statement saying that they have lifted the pause, that they will still appeal it, but they've lifted the pause for now. So they are processing those cases as of Friday. Okay. Let's see. Do you know the wait time for removing the conditions from a 2-year green card? It was obtained by K1 visas. Removal of conditions take 2 to 3 years. That's why they give you a 48-month extension. At minimum, that's just what we're seeing right now. Everything other than marriage-based cases and naturalization are taking a really long time. Okay. Yeah, right. Someone says Mac 1, easy now. I know, right? He's been asking and typing the same question, even though I've answered the question, because your question doesn't make any sense. So you might want to ask that again. I came in 2019 legally and live on pending asylum. If I marry a US citizen and I need to country out and I need to file under this, I don't understand the question. I'm sorry. I don't understand your question. Sorry. When can I file for valid cancellation of removal proceedings after I receive the PFD? Well, the question is, are you in removal proceedings? You have to be in, if you're in removal proceedings, you can just file it right away. You can just, that can be your claim to stay here. That's what you'll be pleading. VAWA is different from VAWA cancellation. So VAWA is filed with USCIS, and that's where you get a prima facie determination. VAWA cancellation is filed with removal in court, meaning that you're already in removal proceedings. And understand with VAWA cancellation only covers spouses of U.S. citizens or LPR green card holders and children of U.S. citizens or green card holders, or the parents of an abused child of another U.S. citizen or green card holders. The exception here is that it does not cover parents who are abused by their U.S. citizen child. So in a regular VAWA case, parents who are abused can apply, but if you're in removal proceedings and you're pleading VAWA cancellation, you cannot, as a parent, stating that you're not eligible if your abuse is from your own child. And also understand that with VAWA cancellation, you have to have been in the United States for at least 3 years up until the date that you received your notice to appear in front of an immigration judge. Okay? I filed VAWA in November of 2022, and I still have not been approved. Can I just get another lawyer? Another lawyer is not going to change that decision. That's the normal timeline. They are processing 2022 cases. So, it sucks that you're tired of waiting. And unfortunately, you can't really blame your lawyer for that, because most of us lawyers don't control that wait time. You are in a normal wait time. If you told me maybe you applied in 2020 or 19 or something, then one can look and see what's going on with that. But you are in a normal wait time, and jumping around law firms is not really going to change that. Okay. My husband filed for my daughter. She's in Jamaica. However, I-130 has been approved. With the I-824, will that go to Jamaica Embassy to continue the process, or USCIS has to approve it also? So if your husband did the I-130 and she's in Jamaica, did he not already select in the I-130 that they were consular processing? So that's the first question, because he didn't need to do the I-824. If you did a standalone I-130, they should automatically have sent it to the National Visa Center. So I'm not sure what happened there and why he's doing that, or if there was a mistake, thinking she was here in the U.S. So that should have been sent there. But assuming that's not the case. An I-824 has to be approved by USCIS to send it, because an I-824 is basically saying send the approved I-130 over to the consulate, to the National Visa Center, so processing can start. Once they send it to the National Visa Center, they will give you like your case ID and invoice number, and that's when that application process will start. And then once that's completed, it will then move to be placed in queue for the consulate interview. Okay. Okay, I'm going to take one more question. I'm sorry, I'm not answering any questions on asylum. I see someone type in asylum several times. I don't handle asylum cases, so I generally try not to talk about cases that I don't handle and focus on the ones that we handle. Yes. Okay, I'll take one more question on Facebook. Actually, this is a good one. Good morning, Aisha. Thank you for always taking your time to educate us. My question is, can an I-765 be approved while the I-360 is still pending, or does the I-360 need to be approved first? This is a really good question. On the I-360, I'm assuming you file for a VAWA application. There are two types of work permit that you receive with the VAWA application. If you filed an I-765 at the time you submitted your VAWA with an I-485, and your category selected as a CO9, yes, in that case, your work permit will be approved well before your VAWA decision. In order for you to request deferred action and a work permit based on an approved VAWA, you don't need an additional I-765 form. You just need to select that in your VAWA application that you are requesting a work permit. So what typically will happen is that the day before, like a few days before they're about to make a VAWA approval, you will get a C-31. You're saying that you have a C-31. If you have a C-31, first of all, you never should have filed a 765 for a C-31. It's not needed. But with a C-31, you're not going to get that until your VAWA is approved, unfortunately. So if you want to get a work permit or be eligible for work permit before your VAWA case is approved, and you are eligible to file an I-485 adjustment of status, you should be filing an I-485 adjustment of status, because that is the only thing that can permit the I-765 to be approved under CO9 before your VAWA case is decided. Again, it was nice chatting with you guys. Call our office if you would like to schedule a consultation. If you have a specific issue with your case, or you want us to just analyze it or do a FOIA for you or to dissect it, call our office. We're here to assist you. And I will talk to you guys later. Bye.